Ladies and gentlemen, welcome to the National Constitution Center. I am Jeffrey Rosen, the president of this wonderful institution, which is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. And I cannot imagine a more inspiring fulfillment of our congressional charter than the program that we are about to share with you today. With our great partners at the Federal Judicial Center, led by Judge Jeremy Fogel, we have assembled some of the greatest federal judges in the country for 2 days of discussion and conversation about the historic and contemporary meaning of the Reconstruction Amendments. The Reconstruction Amendments are the amendments that were passed after the Civil War to end slavery and guarantee equal rights and voting rights, the 13th, 14th, and 15th Amendment. And we've assembled the greatest historians in the country to talk about their historic and contemporary meaning. What's so significant about this symposium is that it is bipartisan and assembles people of different perspectives for conversation and debate about the meaning of this text which unites us. This is the central purpose of the National Constitution Center. We have recently launched an exciting interactive constitution, which we believe is the best on the web, in partnership with the Federalist Society and the American Constitution Society. And we're asking the top scholars in America from different perspectives to write about every clause of the Constitution, describing both what they agree about and what they disagree about. The College Board has just decided to make this the centerpiece of the new AP exams, and this model, which we're doing with online and in debates around the country and in podcasts and in seminars and symposia like this, is based on our belief that when people of different perspectives come together to debate and discuss the Constitution, genuine illumination can result. So we're going to jump right into it. We have an incredibly important topic this morning, which is the judicial legacy of the Reconstruction Amendments. And we have three of the greatest scholars in America to really dig into the question of what the framers originally understood those amendments to mean. The historic question is hotly contested. There's a lot of history to run through, and I just want to have you hear these great scholars ventilate the best arguments. So I'm going to quickly introduce them. Pamela Brandwein is professor of political science at the University of Michigan and author of Rethinking the Judicial Settlement of Reconstruction. John Harrison is James Madison Distinguished Professor of Law at the University of Virginia School of Law. The author, I guess the John Bingham professor would be better for this setting, but John was here last year for our phenomenal seminar on the judicial and historic legacy of Madison, and we're thrilled to have him back because he is really one of the country's leading authority on the original understanding of the Privileges or Immunities clause, which he's written about at length and with great illumination. And finally, the great Jack Rakove is professor of history and political science, and by courtesy, William Robertson co-professor of history and American studies at Stanford. He's the author of many important books, including the book Original Meanings, Politics, and Ideas in the Making of the Constitution, which won the Pulitzer Prize for History in 1997. Okay, we're going to jump right into it. And John, I want to start with you because your article on the Privileges and Immunities Clause taught me much of what I know about it many years ago when I jumped into this field. Tell us, this is a complicated, well, let me try to frame it this way. My colleague Mike Gerhardt, who's the scholar in residence here at the National Constitution Center, said there are 4 ways that the originals understood the Reconstruction Amendments. First, that it incorporated the entire Bill of Rights. Second, that it was a guarantee of equality so that the federal government couldn't discriminate against citizens of other states in the same way that Article 4 prohibited states from discriminating against their own citizens. Third, that it was a guarantee of certain fundamental rights, like the ones that were set out in Corfield and Coriell. And my gosh, I guess I've forgotten the fourth one. But give us a sense of which of those ideas you embrace, and also, just to finish the question, you've written that the Privileges or Immunities Clause was understood not to prohibit discrimination for all rights, but only civil rights as opposed to political and social rights. So tell us about the difference between the original understanding and the way the clause is understood today.
Yeah, thanks, Jeff. On that first point, the substantive scope of the Privileges or Immunities Clause, there is substantial historical evidence that the drafters of the 14th Amendment, and the evidence is always unclear, and I want to say that immediately, that the drafters of the 14th Amendment regarded the Privileges or Immunities Clause and not the Equal Protection Clause as the primary means by which they accomplished their principal equality goal. Their principal equality goal was to put into the Constitution a statute they had just passed, the Civil Rights Act of 1866, which forbade race discrimination with respect to a list of rights, the basic rights one needs to function in society, especially holding property and making contracts. The language of privileges and immunities came from Article 4 of the Constitution. It had already been in there. The original framers, including James Madison, put it in there. And Article 4 guarantees that if a citizen of Virginia comes to Pennsylvania, that citizen enjoys the same basic rights of ordinary life, property and contract in particular, that a Pennsylvanian does. But in particular, that somebody who does that coming from Virginia to Pennsylvania would not enjoy political rights in Pennsylvania. The distinction between civil and political rights is reasonably well established. It was reasonably well established that that was associated with the phrase privileges or immunities. So they meant a particular body of rights, the one listed in the Civil Rights Act of 1866, which carefully did not establish equality with respect to voting or other political rights, because doing that was much more controversial than doing so with respect to things like property, contract, being able to inherit, being able to pass property in a will. So that's the idea of sort of the categorical limitation of the 14th Amendment. That's one of the concepts that soon dropped out. This conference is in part about the judicial legacy of the 14th Amendment. That idea of categorical limitation soon dropped out in the way the courts came to approach the 14th Amendment. And so by the end of the 19th century, they seem to have thought, the courts seem to have come to think that there's this equality provision with respect to all ways in which somebody is treated by the government. But there's very strong evidence that the framers of the 14th Amendment didn't think it that way, and in particular didn't want the 14th Amendment, except in its Section 2, to deal with political rights because that was so politically controversial. They didn't get to that until the 15th Amendment.
That is great. Thank you for that setup. I was so excited to jump in that I didn't do what I should have done, which is to begin by reading the text. You can either read it on this National Constitution Center pocket constitution with its thrilling and insightful introduction by me and David Rubenstein about the relationship between the Constitution, the Declaration, and the Bill of Rights. Or even better, you can now go on to your mobile apps or online to constitutioncenter.org and read John Harrison, and as soon as he turns in his homework, Akhil Amar, debating the original meaning of the Privileges or Immunities Clause online. But here's what the 14th Amendment says. I have to find it, and then I have to be able to read it as well, so I need some help with that. I'm not going to read the whole thing. Let's start with Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. And we know that that second sentence includes three clauses, which are known as the Privileges or Immunities Clause, the Due Process Clause, and the Equal Protection Clause. Pamela, John jumped in by making a strong claim, which went by quickly, so we have to unpack it. He said that the Privileges or Immunities Clause, which was considered the heart of the original 14th Amendment, was originally intended to apply only to civil rights and not political or social rights. Do you agree, and what is the implication of that today?
Well, I think in terms of the congressional debates, in 1866, when the congressmen were thinking about the fact that we had the black codes that were put on the books after the 13th Amendment was passed. The 13th Amendment, of course, abolished slavery and involuntary servitude, and there's quite a bit of evidence that the Republicans, both centrist and radical Republicans, understood the 13th Amendment to, by its own force, protect these core civil rights: property, contract, suing, testifying, having equal redress for injuries, that this was the division between free labor and slave labor. And when we look at the ideology of the Republican Party, that was the division between slavery and freedom. And what happened after the 13th Amendment, of course, was that the southern states passed the Black Codes, which were laws that denied to African Americans all of these rights. And the Republicans in Congress said, hey, you know, this is a violation of the 13th Amendment. We need to now pass additional legislation. So they passed the Civil Rights Act of 1866. One of the things that they intended to do with the Act of 1866 was to protect these core rights of free labor, which go under the heading of civil rights. And so there's quite strong consensus among Republicans in Congress on these civil rights. Now, in terms of is it captured under privileges and immunities or equal protection, it's really impossible to know that when we are only looking at debates over the Act of 1866. And these debates precede the formulation of the 14th Amendment by about 3 months. But what we can ascertain from the debates is that they tended to use both terms. They talked about privileges, they talked about immunities, they talked about the equal benefit of the laws. And so in their language at the time, they merged these two concepts. And so the thing that I would want to add, at least in a preliminary way, is that the need to distinguish between radical and centrist Republicans is absolutely vital. And one of the things that continues to happen in Reconstruction in the literature on Reconstruction is that folks divide the Northern Democrats who opposed Reconstruction down the line, and then they talk about radical Reconstruction. They say it's either radical Reconstruction or the Northern Democrats, and that historically is a mistake. We need to distinguish between centrists and radicals because the action in terms of how to understand these debates is really in the disagreements and the agreements between centrist and radical Republicans. So just two brief examples about that divergence. Centrist Republicans who held the balance of power. This idea that radicals were in charge is really a distortion. Centrists were in charge, even though they moved to the left. They had a narrower definition to civil rights, right? If civil rights are seen as the rights that define the division between free labor and slave labor, centrist Republicans really limited that definition in 1866 to the rights protected by the Civil Rights Act of 1866. Radical Republicans like Charles Sumner and Thaddeus Stevens included immediately the right to vote and things like access to public accommodations. So centrists had a more narrow definition of civil rights. The other dimension on which these two groups diverged was federalism. And so whereas both groups agreed that the federal government had the power to protect these rights, centrists insisted that states had to deny rights first before the federal government could come in and then protect rights. Now that form of denial included the failure to administer the law equally. And so this is an expansive understanding of state denial of rights. It is not the traditional conception of state action that we have. Radicals, for their part, thought that the federal government could come in immediately and protect rights regardless of state denial of rights. And so these two dimensions, along which radicals and centrists agreed, were already being argued, debated in 1866 prior to the passage of the 14th Amendment. And again, in all of these debates, the terms equal benefit of the laws, equal protection, and immunities are run together constantly. So I would just offer that.
That's fascinating, and you've helped us understand that the question of what was a civil right varied from those who viewed it narrowly to the 1866 rights to those like the radical Republicans who you said would have included things like the right to vote, a quintessentially political right, in the definition of civil rights itself.
But there is consensus that in the Act of 1866, it did not touch the right to vote, nor did it touch access to public accommodations. And these things people were aware of these things at the time. So it's a mistake to say that the Act of 1866 did not contemplate access to equal schools or access to public accommodations, because it was understood at the time that the line between free labor and slave labor was defined by those rights that the Act of 1866 protected.
That is very helpful, and we know that the 1866 Act, and for many the 14th Amendment, didn't include the right to vote because Section 2, which many of its proponents thought was the most important in the entire amendment, said that if southern states chose to deny the right to vote, to African Americans, the basis for apportionment should be correspondingly reduced, suggesting they were contemplating that some states might indeed deny the right to vote.
Yeah, that was an indirect way to try to protect black voting rights, which of course Congress protected with the Act of 1867, which extended to African American males in the South the right to vote.
Great. Okay, in a moment, I want to really dig into the Slaughterhouse cases, which interpreted the amendment in illuminating ways. But Jack, as you've listened to this discussion so far, you're one of the leading writers about and skeptics, in some sense, of originalism. It sounds like the U.S. Supreme Court, by interpreting the 14th Amendment clearly to include the right to vote in cases from Shaw v. Reno to Shelby County, may, as Justice Harlan said in his dissent from the original apportionment cases, have been violating the clear original understanding of the 14th Amendment. Should we be troubled by that?
I wouldn't be personally. I mean, the outcome is fine with me. So Jeff, I suppose in a sense the question you're asking me is how much value should we ascribe to the original understanding? In a sense, you're asking, should we all be originalists when it comes to making sense of the 14th Amendment? Just being a historian, I don't know if I have a dog in that fight. What's interesting to me about the process is to try to think about the question: if you want to get at what did let's say Section 1 of the 14th Amendment or the amendment as a whole originally mean, how would you do it? How would you think about it? How coherent an analysis could you produce of the resulting doctrine? So, in this sense, I think the best approach is something very much like what our colleague Bill Nelson from NYU does in his book on the 14th Amendment. And Bill makes a really interesting argument. Well, he makes a number of interesting arguments. One is that, particularly I think for the benefit of the judges present, to think that searching for the original intent of the amendment will actually give you some binding rules, some binding set of procedures that will really discipline your judicial discretion. That may itself be a delusion. The historical record, as is often the case in so many areas, tends to be open-ended. There are a variety of positions. I think Pamela's alluded to this already. There's a range of opinions on the Republican side, and then you have to toss in the Democrats as well. So the idea that actually trying to come up with one definitive reading of any particular, the clause in general, particular parts of it, that's always going to be really tough, and judges will probably find themselves unlikely to be able to formulate this, with as much decision as we might want. So when I think about the larger process, it seems to me the important distinction to make is one has to think about the 14th Amendment. I think particularly Section 1, but the amendment as a whole as well, is really having two dimensions. From a contemporary perspective, and particularly for the leading members of our audience, there is no alternative to thinking of the 14th Amendment as law itself, and to try to do the best job available using whatever interpretive techniques you prefer to use to figure out both what did it seem to mean then and what should it mean today, and it's for judges to determine how that works. That's why they exercise judgment, because they have to make that kind of decision. But in doing that, I think it's important to recognize that in the very process of framing, the 14th Amendment always had a dual dimension. It was both a political and a legal text. One has to work as hard as possible to sort out privileges or immunities, which rights are embraced, which ones were excluded. But they would also have to remember that when the 39th Congress, after the original attempt to draft an amendment, puts it aside and then comes back to it, they had, as politicians always do, they had multiple motives that they had to respond to. So one part was indeed to develop serious constitutional authority for the Civil Rights Act of 1866 and presumably other legislative acts that would come along to kind of clarify whatever ambiguity there was at the end of the war about this. But they were also going to the polls. The 14th Amendment was framed in part with the congressional elections of 1866 in mind. It was meant to go to the public, obviously particularly the public in the North, and to try to produce or reproduce decisive Republican majorities for the 40th Congress that would be able to sustain whatever course Reconstruction took. And so in that sense, a second critical aspect of thinking about the origins of the amendment is to say that for those purposes, you might only need a certain level of generality. You wouldn't have to sort out, in every specific, what's the exact meaning of privileges and immunities or equal protection or due process. It's enough to have the general principle out there. And so as Nelson argues, and I have to say I find Nelson's argument persuasive. Let's say, if you take Bill Nelson's argument over against the argument that Akhil Amar makes. So Amar makes, I think, a very focused argument that the best way to understand privileges and immunities is to put Barron versus Baltimore, the 1833 case in which the Marshall Court said the first 8 amendments, the core text of the Bill of Rights did not apply against the state. So Amar makes, I think, a pretty strong case to show that leading members of the Republican coalition, and John Bingham, I think, first and foremost among them, were Barron contrarians. They felt that the Marshall Court had got Barron wrong. And so therefore it would be an important consequence of the whole process to correct that error from 30 years previously. But at the same time, I think Nelson makes a very powerful case. This amendment is framed in essentially political terms, that all the themes of antebellum constitutional and political discourse and jurisprudence, they survive, they're replicated in the congressional debates. They don't have to be resolved because they're a bunch of congressmen. And they want to endorse a set of general principles, or what I think actually what Pamela's called in her first book, declaratory rights, which I think is an important concept. It's enough simply to affirm that the rights exist without fully clarifying their content and scope, and then then to go to the polls on the basis. So I think one always has to juxtapose a set of legal obligations, legal opportunities, and a set of political commitments to remember that Congress may not have been fully concerned with working out what all the legal implications would have been.
Great. So you've told us that in addition to disagreeing about the scope of the amendments, there was also a disagreement about the process, and the fact that the southern states were required to ratify the amendment at gunpoint has raised questions among some scholars about whether the amendments even are legally legitimate. And I want to put Slaughterhouse on the table in a moment, but Pam, do you want to respond quickly?
Just a very brief comment. In terms of the original understanding of the 14th Amendment, even if we take that on its face, contract rights did not apply to women equally. And so we can put voting to the side and say, well, even if the 14th Amendment protected contract rights, women did not have equal contract rights under the original vision. And so for folks who feel obligated for whatever reason to stick to that original vision, they would have to confront that aspect, and that's something that is generally not considered.
Fascinating. All right, Slaughterhouse, decided in 1873. Perhaps the most criticized case after Dred Scott when it comes to the 14th Amendment. Scholars from from Akhil Amar to Supreme Court justices like Justice Clarence Thomas have said that everyone agrees that Slaughterhouse was wrong when it construed the Privileges or Immunities Clause so narrowly that it only protected rights that had already been guaranteed in the original Constitution. As a result, said Justice Field in his dissent, if this were the case, then the amendment was a vain and idle enactment. John, what I just want the audience to understand is what the various positions of the dissenters were about the scope of the Privileges and Immunities Clause. Tell us about Justice Field, one of the great libertarians of the 19th century who seemed to see it as a guarantee of equality of fundamental rights, and Justice Bradley, who said that there were certain fundamental rights, including those declared in the Declaration of Independence and in the Corfield-Coriel case, that were protected from state infringement, and basically help us understand the range of positions about why Slaughterhouse was wrong.
Thanks. And one reason Slaughterhouse from the early 1870s is a good case to talk about the difference between seeing the 14th Amendment and particularly the Privileges or Immunities Clause as being an equality requirement or a freestanding substantive guarantee of certain rights without respect to just discrimination. Slaughterhouse itself was about a monopoly in the operation of slaughterhouses in New Orleans created by the government. And a monopoly is intrinsically unequal. It singles out some people as having certain rights, and here the right to run a business, the kind of ordinary sort of property contract, kind of legal entitlement covered by the category of privileges or immunities. So it was possible to criticize the monopoly both on grounds that it discriminated between the monopolist and everybody else, and on the substantive ground that, well, you have a right basically to be a butcher or run a slaughterhouse. And as Jeff suggested, the majority of the Supreme Court disposed of the problem by taking an extremely important step in interpreting the Privileges or Immunities Clause, saying it protects only the rights of distinctively national citizenship. This at a time when the structure of enumerated powers in the federal system meant that matters like property and contract were dealt with by state law and not federal law. So federal law was much more limited, things like the post office and navigable rivers. And so the rights of distinctively national citizenship, which sound to us sort of very impressive, a very limited category of legal protections. So the majority said national rights only. This is about running a business. This is about being a butcher. That's a matter of state rights, not state law rights, not covered by the Privileges or Immunities Clause at all. The dissenting justices first generally rejected that idea, and then among themselves divided as to whether to say no state shall abridge privileges or immunities meant there are what we would think of as fundamental rights, like the First Amendment's free speech right, that are guaranteed in the same way in every state. That's the substantive anti-discrimination view, or the view that Justice Field probably raised both of them because he thought this was a very bad idea either way, or the one that Justice Field certainly pointed to, and Justice Field noted that the part of the Constitution, the Article 4 Privileges and Immunities Clause, designed to prevent discrimination against out-of-state people, was an anti-discrimination, equality-type provision. So both of those ideas of substantive protection on the model of the First Amendment and anti-discrimination protection on the model of the Article 4 interstate comity protection, both of those were in play in the dissenters in Slaughterhouse. But to get to that, you had to get past the first step, is this only rights of national citizenship? Let me add, since we were talking about sort of the change in the court's doctrine to covering basically all legal advantages under the 14th Amendment, and hence including the right to vote, I think the Slaughterhouse cases were a very important step in that direction by accident, because the justices wanted to limit the scope of the Privileges or Immunities Clause, probably in order to limit the power of Congress to enforce it. The majority took this position about distinguishing national citizenship rights from state citizenship rights. They then had to go somewhere else to find what they knew was in there, the equality requirement that forbade the black codes. They went to the Equal Protection Clause. That required that they expanded the Equal Protection Clause, and to some extent they'd sort of cut themselves loose from the text, and without realizing what they'd done, had put themselves in a position where they could say the 14th Amendment, other than in Section 2, covers voting rights. So the process by which they came to that position, which is completely familiar to us today, was to a substantial extent accidental.
Fascinating. Okay, Pamela, I really want the judges in the audience and our entire audience to understand what would happen if Slaughterhouse were overturned. Let's imagine that the Supreme Court overturned the Slaughterhouse cases and was free to construe the Privileges or Immunities Clause. How should it construe it? We've talked so far about a variety of ways of identifying which rights are protected by the clause, the rights in the 1866 rights, the rights declared by the Corfield and Coriell case about the right to engage in the ordinary occupations of life and a prohibition against monopolies. Much of the entire Bill of Rights is another option, or maybe it's a license to identify new rights. The final thing I'll say is that Judge and Professor Michael McConnell has suggested that the framers at an intermediate level of abstraction saw privileges or immunities as fundamental rights that were uniform from state to state, available as a matter of right and not privilege. Basically, if Slaughterhouse were overturned, how could and should a judge decide which rights are privileges or immunities?
I think I'm going to take your question in a particular sense, because what I'd like to sort of address first is how much doctrine and how much leeway remained for the court even with Slaughterhouse. Because there is this idea that Slaughterhouse very much gutted quite a bit of congressional power to enforce the Reconstruction Amendments. And so I just want to indicate first that Slaughterhouse left intact quite a lot. It left intact an understanding of the 14th Amendment as including state neglect as a form of state action. Justice Miller, in his opinion, explicitly says that the southern states have not been reconstructed, and that the lives of black men were at the mercy of of whites because laws were not being enforced. Justice Miller explicitly alludes to a concept of state neglect. Justice Bradley, who loses in Slaughterhouse, is responsible for articulating in his Cruikshank Circuit opinion in 1874, which folks tend not to read, a very elaborate doctrine of rights protection, where he not only articulates this notion of state neglect, he lays out a very powerful 15th Amendment jurisprudence. And so the court at the time is not much hampered by the fact that the 14th Amendment did not include voting, because the judges did, they turned immediately to the 15th Amendment. Bradley articulates a non-textual reading of the 15th Amendment where he excludes, he exempts that amendment from state action doctrine. That is the doctrine, along with the federal elections law that Bradley also articulates, that the Justice Department, starting in 1877, after that disputed election in 1876, they take Bradley's cues that Bradley laid out in 1874, and voting rights enforcement goes up in the 1880s. There are cases that folks are not generally familiar with around Reconstruction: Ex parte Siebold, Ex parte Yarborough. Klansmen go to jail under these cases, under the 15th Amendment. These are voting rights prosecutions. And so I just want to underscore in a preliminary manner that folks at the time were not worried about the fact that the 14th Amendment did not protect voting rights, because Justice Bradley of all people, hands the Justice Department actually quite a robust 15th Amendment jurisprudence. There's a historian by the name of Ji Wang. He's written the book called The Trial of Democracy, where he gives us the numbers of federal prosecutions under the 15th Amendment, under the conventional understanding of state action doctrine, which suggests that handcuff the court, those prosecutions would have been impossible. And so just to underscore the history of the interpretation of privileges and immunities, it's not nearly as devastating for the protection of black rights during Reconstruction as is conventionally imagined. Now, what would have happened if privileges and immunities had not been overturned or had not been gutted? And again, just one more footnote, I apologize, and I'll be brief. Michael Ross, he's a historian who's written an intellectual biography of Justice Miller. He has suggested that the court gutted privileges and immunities because the moderates were worried about the libertarians like Field. And they were quite worried that Justice Field would turn to the Due Process Clause and use the Due Process Clause to invalidate the regulations of business. Justice Miller and the members of the majority wanted to sustain regulations of business, and they were quite worried that Field and folks of his jurisprudential orientation were seizing on that Due Process Clause in order to do that. And so it was a defensive measure to block Field, but that did not mean that they were hostile to Reconstruction in general, and we can look at subsequent jurisprudential developments in support of Michael Ross's hypothesis. Now, the one thing that certainly would have happened if P&I had been sustained, for sure, as a state action requirement, would have been part of this. It would not have given Congress or the federal government the power to come in and regulate anything they wanted, regardless of state behavior. That state action requirement absolutely would have been there. That was there for the centrist Republicans. And in the interest of time, I will just stop there to preserve more time for the panel.
Fascinating. John, you, I think, have something to disagree with.
Well, I want two things I wanted to say. One is sort of getting down into the legal weeds about
Yes.
the state action principle, and down in the weeds, it is important if the premise is accepted that state neglect can violate the Reconstruction Amendments. There is then an important, somewhat technical but follow-on
Limited
question.
to certain rights.
Right. Yes, absolutely. With categorically limited. Exactly what Congress can do about that through its enforcement powers. And in particular, whether in response to that kind of problem, Congress can then itself act affirmatively to itself secure individual rights, or whether the way Congress has to deal with that problem is to act on the state governments to make them do what they're supposed to do. So
Okay, I would say the
right,
primary.
well, exactly. But
Yeah.
there's then a dispute about that one. That second question. It's important to see that that's a distinct question from can state neglect violate the
No,
amendments.
absolutely. Although there seems to be consensus at the time that the federal government could not force state officials to act in any particular way. And you see quite a bit of conversation among congressional Republicans saying, well, as it is the case that we cannot force state officials to do anything, the federal government must then come in and act directly on the perpetrators. But they're quite clear that acting directly on the perpetrators is predicated on states not punishing the perpetrators.
Now we're in the weeds, which is great.
It is great, but let's also get to
And we're running
the
out of
bigger
time.
question of what privilege. You want to stop there? Okay,
Yeah.
good. Jack, let's pull back for a second. Our judge.
I won't be any good in the weeds. I'll say that right now.
The weeds are an important place to be, but we're now going to go to the beautiful forest and look at the lush greenery before us and ask this question, both for our judges and our great C-SPAN audience too. One thing that I hear as I listen to this important discussion is that judges matter. They matter a lot. Had the Slaughterhouse cases come out the other way, the Bill of Rights might have been applied against the states nearly a century before it was. Had judges not interpreted the 15th Amendment to allow the federal government to punish private individuals who created race-based violence, as Pamela says, then more of that might have gone unpunished. What is your evaluation of how judges performed during this crucial post-Reconstruction period? Were they faithful to the best ideals of the Reconstruction Amendments, or did they thwart them?
You know, I don't think there could possibly be a simple answer, Jeff, to that kind of question. In kind of my premises, I have to say I'm mostly an 18th century guy. Really, that's where I spend most of my waking hours. So I am taking kind of a long view of this. I mean, part of my understanding of Slaughterhouse is that it represented an early effort on the part of the court, and this I'm probably overgeneralizing here, but a kind of early cautionary effort to realize that if you had a truly broad reading of privileges and immunities, the flood of business coming into federal courts thereafter would be enormous. It would probably swamp the docket. So in kind of simple prudential terms, trying to control the body, the amount of controversy available, a narrow reading would make a certain kind of, I'll say, administrative sense. But of course, what happens in the courtroom doesn't, constrain lawyers or litigants from, trying to take as much legal advantage as they can of whatever legal opportunity still seems to be available. You'll take it to court and see what happens. I think as Pamela's point just now illustrates this very well. It may well be that privileges and immunities was effectively closed off, maybe not as much as one thought, but was certainly sharply curtailed. I always understood part of Corfield and Coriell does include a reference to the Bill of Rights as being, among the privileges and immunities of citizens. So that option was intellectually, conceptually available from the very beginning. The court seems to close that off, and it takes a long time for the incorporation doctrine of the 14th Amendment to work its way into American jurisprudence. But the concerns of litigants continue to arise, and the ingenuity of lawyers continues to find ways to try to develop arguments that a judge here or a judge there might want to take seriously. I mean, I know in the case, in the recent case of privileges and immunities, I know there's a lot of interest. I have a big concern with the Second Amendment, which is something I've written about, with the idea of kind of reviving or kind of overturning Slaughterhouse in order really to open up the possibility of even more judicial intervention in terms of enlarging the scope of what the right to keep and bear arms might mean. On the whole, I think it was a good idea. The court didn't go in that direction, but potentially the option was there. So I think if you're a historian like myself and not really trained as a lawyer, trying to understand the system from without, I think what one appreciates is the amount of ingenuity that can go into legal practice. Whether it's the genius of litigants and their lawyers or the ingenuity of judges to accept arguments. There's always an array of legal arguments out there that the ingenious judge can pick up on. I mean, I look at Shelby County, which is a decision I hardly support as a kind of interesting example. Is the court can always develop, courts can always develop a new theory or kind of take an existing body of doctrine and develop, new twists on it to really enlarge the realm of our jurisprudence. I don't know if that's a good thing or a bad thing. Arguably, it's problematic. But if you're not in the weeds, thank God I'm not in the weeds, and I'm just trying to admire or try to make sense of how the system works from outside. To me, that's one of the most interesting things about our constitutional jurisprudence.
Well, that is a helpful reminder that there are strong arguments on both sides of this debate and that there's a lot of discretion for judges. It's time for closing arguments, and we're going to spend the next few days engaging in this question of what the original understanding was and what its contemporary application is. We have one question from the audience which I'm going to pose and then ask you to sum up. The question is, should we draw any meaning from the Privileges and Immunities Clause being listed before due process and equal protection? And the question I'm going to ask each of you, and really with the yellow light, let's give the 2-minute version, the elevator speech version, of whether it matters that privileges or immunities came first and what the Privileges or Immunities Clause was originally intended to achieve in your view. John.
I don't think it particularly matters that it comes first, but I think it very much matters that it is there. I think its primary point was a requirement of general equality among citizens with respect to the basic rights of citizenship. I think it's entirely possible, but I'm never sure, that it was also designed to apply what we now call the Bill of Rights to the states. Let's see, today is an odd-numbered day, so I'm going to say I don't think that. but on even-numbered days, I do. That I think is a very close case. But I think its primary point was equality in the sense of all citizens having the same civil rights with respect to that very important but circumscribed category of civil rights.
Beautiful. Pamela, does it matter that privileges and immunities came first, and what was the Privileges and Immunities Clause originally intended to achieve?
I think it matters that the Citizenship Clause came first. The Citizenship Clause was meant to formally overturn Dred Scott in that absolute basic way. I think privileges and immunities covers the original incorporation of the Bill of Rights. It also covers equality in those core civil rights. But I don't think the fact that equal protection and due process come last suggests any lesser status.
Great. Last word to you, Jack.
I don't think the sequence matters. I think the three clauses would have been regarded as being complementary to each other as opposed to implying some kind of sequential order or sequential privileging of one over the other. But I do think historically it's interesting to think, and what I try to teach my students is try to emphasize how privileges and immunities is closed off, how due process, looking ahead to the Lochner era, becomes kind of the next wave of the enforcement of the 14th Amendment. But in the end run, it's equal protection that triumphs over all. So there is a kind of sequential aspect, I think, to the history of how the clause is applied, which makes it, at least for undergraduates, and I hope for the C-SPAN viewers, if not for the judges, one way to conceive what's going on in the second sentence of Section 1 of the 14th Amendment.
Wonderful.
They also overlap. They're not mutually exclusive clauses, which I think it's very important to underscore.
Great. Well, both judges and C-SPAN viewers, you can see both how incredibly rich and important this is and how much there is to learn. So I want all of us over the next couple days, and C-SPAN viewers throughout your lives, go learn more about this subject. Go to the startatconstitutioncenter.org and read the interactive Constitution with the explainers from people like John Harrison and Akhil Amar. Read more deeply and make up your own minds about this crucial project. I should also say the National Constitution Center, in partnership with the Constitutional Accountability Center, is launching a 5-year initiative to celebrate the 150th anniversary of the Reconstruction Amendments. And on December 7th at the National Archives, we're going to celebrate the 100th anniversary of the ratification of the 13th Amendment, and where that's going to continue over the next 5 years. So it's going to be an amazing period of education, debate, and learning. Ladies and gentlemen, we'll reconvene in about 15 minutes for our next panel. Please join me in thanking our great panelists.
Shake hands?
Absolutely. The best panels are those that go so fast that you want them to be a lot longer.